The boy they tried twice. The Willie Francis tragedy. They strapped a teenager to a wooden chair they called Gruesome Gertie, tightened the leather hood, and told the witnesses to prepare for silence. The switch dropped. Electricity tore the air like a storm. And then, from inside the hood, came a voice. Terrified, ragged, unmistakably alive. "Take it off! Take it off! Let me breathe!" In a room built to end a life, life shouted back. The current had failed. The state had tried to kill 16-year-old Willie Francis and failed to finish the job. The officials paused, the witnesses stared, and somewhere beyond the shock and the smoke, a new question began to burn. What does justice mean when the punishment itself goes wrong? Before that day, Willie was a quiet black boy from St. Martinville, born January 12, 1929, in a South where the color of your skin could weigh more than the truth. He swept floors, ran errands, and for a time worked around the pharmacy of Andrew Thomas, a respected white man. When Thomas was found murdered, rumor outran evidence, and suspicion clamped onto Willie with speed. He was arrested, questioned without a lawyer, and rushed before a courtroom where guilt felt assumed. The trial was quick, the defense thin, the verdict predictable. A judge's voice carried the sentence that would carry the boy toward a machine built to stop hearts. They brought the chair because St. Martinville had no permanent death chamber. Gruesome Gertie was portable justice. A wooden throne of straps, buckles, and wires hauled from parish to parish like a terrible carnival ride. On May 3, 1946, guards strapped Willie down. A black hood swallowed his face. A gag pressed his mouth. The room filled with that anticipatory hum. Then the power surged, stuttered, and misfired. Willie convulsed but did not die. The executioner cut the current. The witnesses stared at a boy who was supposed to be a body. He cried out to breathe, and the ritual collapsed into confusion. The state had promised certainty. Instead, it delivered a question mark. News of the failure rippled through Louisiana. To many, it was a grotesque spectacle. To a few, a constitutional crisis. Among the latter was a young attorney named Bertrand de Blanc. He wasn't famous. He wasn't a movement. He was a lawyer who believed law must draw a line between punishment and cruelty. De Blanc took the case and made a plain argument. Forcing a teenager back into the same chair after the first attempt failed would be cruel and unusual, and it would, in spirit, punish him twice for the same offense. He filed papers, cited principles, and asked a simple human question dressed in legal clothes. How many times can the state try to kill you? The case climbed from parish courthouse to the marble steps of the United States Supreme Court. The caption was Sterile Louisiana ex rel. Francis versus Resweber, but the stakes were human. Can the government take a second shot at death because the first shot misfired? In early 1947, the court split. A narrow majority said yes. The first attempt, they held, was an unforeseeable accident, not a separate punishment, and a second attempt would not violate the Eighth Amendment's ban on cruel and unusual punishment or the bar against double jeopardy. For justices dissented. 5 votes were enough. With careful words and cool logic, the law cleared a path back to the chair. Back in St. Martinville, the ruling became a date on a page. The state set a new execution day. Willie had turned 18, still slight in the shoulders, still soft-voiced with the priest who came to see him. He wrote to family. He prayed. He waited while the world decided what to do with his breath. May 9, 1947, arrived without fanfare. The witnesses assembled. The chair stood in grim simplicity, the instrument now corrected, tested, ready. Willie walked in under guard, sat, and did not struggle. The straps tightened. The hood came down. The switch dropped. This time, there was no voice from beneath the leather. The room found the silence it expected the first time. But death did not settle the questions. In the years since, scholars, judges, and citizens have returned to Willie's story like a tooth we cannot stop prodding. Some doubt he was ever truly proven guilty, given the speed of the trial and the climate of the time. Others, even convinced of his guilt, remain haunted by a government returning to finish what it botched. It felt like punishment laid atop punishment, as if the first attempt had become a separate penalty no statute had authorized. The image of a traveling chair, a boy's cry, and a second try pressed against the nation's conscience, demanding that we say aloud what lines, if any, the Constitution draws when the machinery fails. Bertrand de Blanc never became a household name, but he left a record of stubborn decency. He showed that a single lawyer with the Constitution and conscience could force the highest court to say plainly what the law allows. The answer they gave, a technical permission couched in careful words, still governs when executions go wrong. When a needle infiltrates a vein, when a protocol fails, when equipment sputters and stops, judges reach back to Resweber. They find the same uneasy logic. An error in method is not a second punishment. The rule is tidy on paper. In the human ear, it hums like a wire and leaves a scorch. Yet Willie's name endures not because of casebooks, but because of that cry beneath the hood. Let me breathe. It cut through leather, law, and the heavy air of a crowded room. It braided a teenager's terror with a universal plea. When the state grips the switch, it is easy to talk about procedure, harder to talk about dignity. But dignity is the point. Not to absolve, not to ignore harm, but to insist that even at the edge of sanctioned death, humanity still claims a boundary the government must not cross. If the process itself becomes a kind of torment, then the process is the problem. So remember the dates. May 3rd, 1946, when the machine failed. May 9th, 1947, when it did not. Remember the town, St. Martinville, and the boy who grew 2 years older between attempts. Remember the lawyer who refused to look away, and the justices who, divided, wrote an answer we still live with. Remember the wooden chair built to travel, as if death were a service delivered on demand. Willie Francis left no long speech. What remains is a story that keeps asking, what do we owe the least powerful when the state decides how and when a life ends? What is punishment for, if not to affirm a moral order that never resembles cruelty? And what becomes of all of us if we answer with indifference? Click the like button, share and subscribe for more chilling true crime story.